Texas allows introduction into evidence of the fact that a person is not wearing a seatbelt. So if you were injured in a car wreck and your injuries were enhanced because you didn't have a seatbelt on, the defense is allowed to introduce that into evidence, and the jury is allowed to reduce the amount of money you would get because you were at fault yourself for not wearing a seatbelt. The basic answer to that question is yes. Failing to wear a seatbelt is admissible at trial and is something that can and will be used to reduce the amount of compensation you would receive.